Today's topic of revision is public law, and I will teach you how to get a high grade and first class in public law. The key to getting a first class is to do a selective studying. So what does this mean? Basically, what you need to do is review everything that you have learned in public law, or otherwise called constitutional and administrative law, in your course, and select the topics that are most likely going to come up on the exam. If you have a coursework, the question is already out and you don't need to do this. But if you have an exam, that's when the selective studying technique comes into play. So you need to have a look at everything that you've learned on the course and select the topics that are mostly going to be coming on the exam. How do you know that? By looking at the past exam papers. Most of the times, universities give you at least 3 years of past exam papers, and you can review those past exam papers. That will give you a very good idea of what kind of questions you can expect on your exam, and then select the topics from there. So from my experience, these are the topics that are usually coming on public law exams, and you should be revising those topics. Not only revising, but you should also draft problem or essay questions on these topics from the past exam papers to be well prepared. Believe me, if knowing the law is 50% of the work you need to do, but knowing how to apply that law to essay and problem questions, that's another level that requires lots of practice. This is not something you can learn in a day or two. It requires lots of practice, and you need to practice before your exams. If you just study by heart everything about parliamentary sovereignty, for example, most likely you're not going to get a high grade. Most of the time, students who do this actually fail the exams because you just know everything that you covered, maybe on the course, but you don't know how to answer an essay and problem questions. And most of the times, well, all the times actually, they don't ask you write everything you know about parliamentary sovereignty. They ask you to answer the question asked. And students who do not practice do not know how to answer the question asked. So my advice would be answer the past exam papers, the problem and essay questions from there as much as possible before the exam if you want to get a first class. Rule of law, constitutional convention, separation of power, human rights, these are all the topics that most likely will come up on your public law examination, and I suggest that you revise them as well as answer essay and problem questions on these topics. Well, for public law, most of the times it's essay questions, so you should be prepared to answer essay questions. Today's topic will be constitutional conventions. So we will revise this topic as well as answer an essay question on this topic. Example essay that you may get on constitutional conventions is the following. Constitutional conventions are an important part of the English legal system, discuss advantages and disadvantages of the uncodified nature of the constitutional conventions. So how do you answer this question? First of all, you need to remember that this essay is not asking you to write everything you know about uncodified nature of the UK Constitution or constitutional conventions. Neither it is asking you to just put the definitions and cases in there, because I highlight this point because most of the times I see students making this mistake over and over again. And this is very, very important for you to remember. Do not write everything you know about the topic, answer the question asked. The plan is you start by the introduction. Introduction should be about 10% of the essay. So you need to prepare and plan accordingly. For example, if you have 1 hour to answer the question, they cannot possibly expect you to write more than 1,000 words. So if you are expected to write 1,000 words on the exam for answering this question, you would need 100 words for the introduction. Then you would do the body paragraphs, which are the arguments, that's where you present your arguments for and against, or whatever the essay is asking you. And then at the end, you need to sum up your main arguments and answer the question asked in the conclusion. Conclusion will also be about 10% of the essay. So again, 100 words. If we're talking about an essay of 1,000 words, it would be introduction and conclusion, 100 words each, 200 in total, and body paragraphs would be 800 words. Also, it's very recommended that you time yourself. So on the exam, if it's a timed exam, well, if it's a 24-hour exam, then you have more flexibility there. But if it's a timed exam, like 3 hours, 4 hours, you are really limited in time. So not only you should be able to answer this question, but you should be able to answer this question within the time limit given. So it's a very good practice to time yourself when you do the practice before the exam. The introduction would start by defining constitutional conventions. What are constitutional conventions? This is where you can explain and always cite the relevant authorities as much as possible. Examples of constitutional conventions. So there is no case that would give you an exact definition of what is a constitutional convention. So you shall give examples. Explain what does it mean that the UK has an uncodified constitution and what is uncodified nature. Explain the problem with law being codified and this statement. So these are the things that the introduction must cover in that 100 words if we are analysing the case of 1,000 words essay. This statement would be basically announcing the plan of the essay, and we will cover that in more detail. So what are constitutional conventions? UK has an unwritten, uncodified constitution that changes every day. Dicey define constitutional conventions as understandings, habits, or practices of the constitution. Constitutional conventions are unwritten rules and practices that are considered binding and have constitutional significance. So things that are not written in law specifically, but they are accepted habits and practices. This is how the UK constitution works. Examples: judiciary power often regulated by conventions. Prime Minister authority is not actually codified, it's a constitutional convention. Royal assent to legislation is also a convention. Judicial independence, the Salisbury Convention, all establishes House of Lords should not oppose legislation that was explicitly mentioned in the government party's manifesto. So all these things are the examples of what are constitutional conventions, and you should memorize them. What is the problem with uncodified nature of constitutional convention? So what are the advantages and disadvantages? Constitutional conventions are created in accordance with historical practices, precedents, and political norms. The problem is that it's unclear. So once you have something codified in the legislation, it is clear, it's accessible to public, it's written, and that certainty. And usually certainty is preferred in law. So the disadvantage is that it's unclear, and the rule of law requires the law to be clearly written and transparent. So that is the main problem with constitutional conventions. The present essay shall critically analyse the uncodified nature of constitutional conventions in the UK, discussing its advantages and disadvantages. For an essay question like this on an exam, where you have very limited time, right, 1,000 words you can write max, I think this is enough for this statement. You're just announcing the plan of what the essay will cover, what the critical analysis will be about. Now, list the advantages, but not just list them like bullet points like I've done here. You have to elaborate on it in the essay as much as possible and cite relevant authorities. So first of all, constitutional conventions uphold the independence and impartiality of the judiciary. So these are the advantages. A constantly evolving constitution that adapts and reflects to change. Basically, flexibility and customization. When you need to change the law, it can be very time consuming. It's an unflexible process. but constitutional conventions can be changed a lot easier, a lot faster. So that's the flexibility and customization and evolving nature of the constitution that can count as a big advantage for constitutional conventions. For example, in the UK, the election of the Prime Minister is a constitutional convention. Prime Minister is only elected for a limited period because unrestrained Prime Minister can influence the Supreme Court. So here it refers again to the argument about independence and impartiality. So Prime Minister is elected for a limited time, so they cannot influence the Supreme Court, and the judiciary stays independent. Also, you can mention Section 4 of the Human Rights Act, under which UK judiciary has a right to issue declaration of incompatibility. So any law can be declared incompatible with human rights. And this is a good demonstration of independence of judiciary in the UK. They can actually oppose Parliament-made legislation, declare it as incompatible with the human rights. Advantages continued. So there are more advantages that you can mention, for example, political guidance. Constitutional conventions can be guidance and direction in areas where there may be gaps and ambiguities in written laws. You cannot actually, you cannot predict every kind of scenario and codify every single thing in the law. And once we have constitutional conventions like this, it can guide unprecedented situations where there is no law really, and constitutional conventions can come in to provide the much needed guidance and directions when the law is ambiguous. Balancing powers, system of checks and balances between the three branches of government, legislature, judiciary, and executive. The checks and balances can be also considered as an advantage of constitutional conventions. Democratic accountability, providing expectations and norms for the conduct of government officials. This is related to the accountability of government officials, and these are like, it establishes what is expected from them, what is the norm, how the government officials should behave. And this is not guided by the codified legislature, but it's guided by constitutional conventions. Disadvantages: lack of legal enforceability. This is not something you can rely on in the court. Like laws can be cited as an authority when a case is presented in front of courts, but this is not the same for constitutional conventions. This is there is no legal enforceability for constitutional conventions. Uncertainty and ambiguity is another disadvantage. Unwritten rules are interpreted differently, so there can be like differences in interpretation. Again, it raises uncertainty, it raises transparency is undermined when the rules are not written. Lack of clarity can lead to disagreements. You could refer to the case of Anna Frieva to support this argument. In this case, there was a disagreement as to the Constitutional Convention, and this case can be a good authority for demonstrating what kind of disadvantages constitutional conventions can raise in terms of uncertainty and ambiguity. Potential for abuse: the flexibility can be good and bad. When the law is too flexible, it could lead to it being manipulated, interpreted differently, disregarded by politicians. Lack of public awareness, lack of transparency. It is the basic principle of the rule of law that law should be written and transparent. Therefore, constitutional conventions goes against this principle. You can refer to the case of Antique versus Carrington supports this argument. How to make an argument. This is also a very important thing that you need to remember. In an essay question, you need to first explain the law that you are relying on. For example, either the cases that we mentioned before, the case of Entic or the case of Anaviva or Dicey, whatever you are relying on, the authority you are relying on, you have to first explain that. And then you need to analyze the law and explain its significance for the purposes of the essay question. Not only, like, obviously you need to explain the law that you're relying on, but avoid being descriptive. The question here is not to just explain and leave it like that, but explain its significance. Why did you choose this case for the purposes of answering this essay question and not another? What is the point that you're making? What is the argument that you're making? Refer back to the question asked and make an argument. Here, the most important is that you present very clear and strong arguments to explain why constitutional conventions are good or bad. If you cannot find a primary law to support your argument, you can use peer-reviewed journal articles in an essay question, but not in a problem question. If it's a problem question, it shall be primary law, shall be cases and legislations, whereas for essay questions, we often use peer-reviewed journal articles as well. Support your argument with case law and statutes and peer-reviewed journal articles. So make sure that everything you say is cited, is supported by the relevant authorities. So once you explain, let's say, rule of law, what is rule of law, you need to cite relevant authorities. Once you explain what is a constitutional convention, or whatever you're explaining, you have to be citing the relevant authorities. You can cite books as well, that would be fine. And at the end, you need to conclude, you need to sum up all the main arguments that you've made and answer the question asked. The question was, after analyzing advantages and disadvantages, would you argue that constitutional conventions should stay uncodified and why? So this is the main question. For a first class, the best practice is to not only present advantages and disadvantages, but also say what is a possible solution. So the first class is usually awarded to students who go extra mile. So, for example, you have identified the problems with constitutional convention and the disadvantages, but what is a possible solution? What do you think? Should they stay uncodified or not? If you present arguments that are well researched and backed with credible authorities, that would normally result in first class. And finally, I'd like to give you a little bit of information about simple studying and how we can help you. We are a team of law graduates, so we have achieved very high grades in our law degrees. We come from different UK universities like City University of London, BPP, Keele, University of Leeds. We're not associated with these universities, but we hire their best graduates. And the best graduates from these universities create our study materials and tutoring services that you can access on our platform. We strongly recommend that in addition to our first class study materials that you have on our platform, you get personalized tutoring as well. From our experience, 6 hours of tutoring is usually the best package for a student to get a first class. So you start studying by our materials, plus you get tutoring sessions for personalized support, and that usually should be resulting in a first class. We have already helped over 20,000 subscribers that we have on the platform to get very high grades. You can see the reviews here. And if you want to get a first class, we suggest you start studying with us as soon as possible. Thank you very much.